Good morning. Today we are going to discuss defenses in tort. They are also called as justification in tort. Being an advocate, a plaintiff may come to you telling about his story that some wrong has been done by the defendant, some tort has been done by the defendant, better file a case on behalf of me. So, you as an advocate will file a case for the plaintiff. But sometimes it may happen that the defendant will come to you and he will give you the summons and the copy of the plaint and tell that, see, a case is being filed against me and a summons is there of the court. So you are going to read the plaint, the story of the plaintiff, and you have to console your client, that is a defendant. Don't worry, we will take a defense, we'll take a good defense, and you are not liable for anything. The plaintiff is not eligible for getting compensation or any other remedy. You have to protect your client. Here you are the counsel, the advocate of the defendant. So you have to take certain defenses. There are many defenses which you can take depending upon the facts of the case. Here we are going to discuss about some of the defenses in tort. The first defense is volenti non fit injuria. Volenti non fit injuria means the plaintiff has given the consent to do certain things to the defendant. The defendant has done it according to plaintiff's consent, and now plaintiff is complaining. The defendant will tell the court, plaintiff has given me the consent, only because of that I have done this. This is a very good defense. Because the plaintiff himself has given the consent, afterwards he cannot complain. But here the consent should be free from fraud. It should be free consent, fraud or coercion and all, undue influence and all. Therefore, the consent should be free. It can be either express, it can be either implied. Express means by words, clear words, words of mouth, they say, or it can be in a written form. Or the consent can be implied also. That is, by the circumstances, you are going to infer that this is his consent. If something wrong has been done against you, you have to object. If you don't object, it means you are giving them your implied consent, you are waiving your right of objection. Therefore, here it is a very good defense that plaintiff has given me the consent, therefore I have done it. Here you have to make it clear, this is volenti non fit injuria and not sancti non fit injuria. Knowledge of a risk does not mean consent of a risk. Consent is different and knowledge is different. We will take one example. A woman has come, she wants to hire a cab. She hires a cab and that driver is drunkard. She knows that the driver is drunkard, but she sits in the cab. She is sitting in the cab with the knowledge that the driver is drunkard. But it does not mean that she is giving the consent to drive the cab in a negligent manner and commit accident. She is not giving the consent of doing accident. She is only having a knowledge that he is drunkard. Maybe that is the only cab there. Maybe she is in a hurry, or he is the only cab driver who is ready to drop her. Maybe some problems are there. Therefore, she has hired this cab only with the knowledge that the driver is drunkard. So, that is just a knowledge, that is not a consent. This is a very good defense, volenti non fit injuria. The second defense is the judicial or quasi-judicial acts. When a judge, taking into consideration the evidence before him, his knowledge of law, his own interpretation, his discretionary powers, he has given a judgment, and that judgment is overruled by the superior court, the lower judge is not responsible. The lower judge is not liable for wrong decision. He is having jurisdiction to decide rightly and wrongly, but in good faith. Therefore, judicial acts and quasi-judicial acts, quasi means similar. Similar to judicial, there are certain officers, executive officers, who decide who adjudicate, they are also protected if they are doing anything, they are taking any decision in good faith. Therefore, executive acts, judicial acts, quasi-judicial acts, they are also good defense. Similarly, parents and quasi-parental authorities. Parents and quasi means similar to parents. You can take teachers. Teachers are also quasi-parental authorities. Both are acting in good faith for their children, for their students. Therefore, if they use reasonable is the main thing here, reasonable force towards the children, then it is not a tort. That is a good defense. So, parents and quasi-parental authorities are having a right to use reasonable force because they are doing it in good faith and for the betterment of the child. So, parents and quasi-parental authorities are also not liable. This defense the defendant can take. I am parent or I am a quasi-parental authority, I am a judge, I am acting in good faith, therefore not liable. Okay. Now, the next defense is private defense. If somebody is coming and trying to hit us, it is not a case like we will get hit, get beaten by him and then come to the court. Law is giving you the right of private defense. You can defend yourself, but while defending also, you have to use reasonable force. You have to defend, and while defending, you can use reasonable force. You are allowed to do this. So, in tort also means in crime also, private defense is a very good defense. How many defenses we have seen? We have seen voluntary non-fit injuria, judicial, quasi-judicial acts, executive act, parental, quasi-parental acts, okay, private defense. Everywhere you can say there is a reasonable, there is a good faith, then only it is a good defense. The another defense is accident. The thing happened because of an accident. So, I was not having intention to do it. It happened. It was beyond my control. If it is something which is beyond your control, you try to stop it. Inevitable. It was inevitable. It was a lawful act. By lawful means, you tried to stop it, but it happened. So, what I can do now? That is beyond my control. Therefore, it is a mishap. It is a mishap. It is an accident. It happened accidentally. The defendant can take this defense and he will be relieved from the liability. He will not be liable. Accident is also a very good defense. And the last defense which we are going to discuss is vis major. Vis major means act of God. God is not liable for anything. Act of God here means the natural acts, the earthquake, floods, snowfall, heavy rainfall, the earthquakes and all natural calamities. The natural calamities which take place, for that, who is responsible? Nobody is responsible. We have to face it. We have to rehabilitate the people who are affected. But we can't make liable anybody because it is an act of God. But in reality, it should be act of God. It should not come in a disguise of something. Man is liable for his act. God is not liable. We will discuss one case here. That case is Nicholas versus Marshland. This defendant was having artificial dams in his land. He had constructed himself artificial dams so that he can take help of the water for his agriculture field. He can store water from the rainfall. So, for that he had constructed artificial dams. One night there was a rain. It was a very heavy rain. They say that nobody had heard about such a kind of rain. For many years together, such a rainfall nobody had seen. Therefore, we can say that it was a very heavy rain. Because of that, the dams got flooded and the water overflowed. It went to the plaintiff's land and it caused damage to his land. Plaintiff's land, plaintiff's agriculture field was fully flooded because of the water which flowed from the defendant's land. Here the defendant took the defense of vis major. He stated that yesterday night there was so heavy rain that I could not do anything. It was an act of God. Rain is an act of God. Got it? So if it is an act of God, then it is God who is liable for that, not human being, and we can't make God liable. So vis major is also a very good defense. But you have to take you have to see in a proper manner that really it is an act of God, or in between some time has occurred and some negligence has taken place, then man will be liable. These are few defenses which the defendant can take and he will not be liable. First we have seen the plaintiff. What plaintiff has to prove? Plaintiff has to prove that defendant has done a tort. He has done a wrongful act. Damage is caused and therefore I want remedy. Those are the elements of tort, isn't it? In the second lecture we have seen that. So plaintiff has to prove that the defendant has done a tort, a wrongful act. There is a legal injury for me. There is a damage. Therefore give me remedy. In that case, the defendant will prove certain defenses. If he is successful in the defenses, the defendant is not liable. The plaintiff's case will be dismissed. Got it? Okay. Bye bye. We'll see in the next lecture.